Commercial litigation mainly deals with questions of contract law between business entities in disputes. A mouthful, but if I were to distill the essence of contract law going back 1,000 years into a word, I could. Contract law is about honesty. Honesty, what do I mean by that? Well, maybe it is helpful to state what contract law isn't about. Contract law isn't about fairness, honesty and fairness. Not exactly opposites, but different concepts. You see, every party to a contract is promising to do something in this vague, uncertain thing we call the future. We have a general sense of what might happen in the future, but we don't really know. Things could go according to plan, or they might not. The world is unfair. Life is unfair. Usually, a well-drafted contract will contemplate uncertain events in the future, and the parties to it will come to an agreement as to which party is taking the risk for certain events to occur. As long as the parties come to an understanding as to possible future events, the court usually won't interpose their wisdom for that of the contracting parties, even if the future turns out to be a very unfair place indeed. I am talking in the abstract. A recent example should suffice. Last month, March 2023, for those of you watching a year later, the New York Appellate Court heard an appeal in the case Landmark Group, Inc. versus New York City School Construction Authority. Landmark Group is a contractor. It entered into an agreement with New York City to perform some work on some of our schools. The project had a schedule that contemplated full working days, but it also contemplated a situation in which the Landmark Group would only be allowed to work at the project site after 3 p.m. from Monday to Friday, presumably because there are kids in school before 3 p.m. on weekdays. At the same time, the contract required Landmark Group to pay its laborers, all unionized, for a full 8 hours each day, no matter what. Lo and behold, there's a development at the project, and Landmark Group is directed by the city to only work after 3 p.m. on weekdays. At the same time, they are still required to pay their laborers for a full 8 hours, 40 hours a week, even though those laborers were only working for 5 hours a day, 25 hours a week. The amount of work is the same, they're just paying more for it. You can imagine what happened to Landmark Group's profit margin at this project. They brought a delay claim against the city in court. They lost. They appealed that decision and last month lost again. It would strike a casual observer that it is unfair to limit the time a contractor can work at a project, but still require it to pay its workers for an entire day. Why did the court allow this? Because the contractor agreed to take that risk, and it would be dishonest if the contractor changed its mind after the fact. Contract law is about honesty, not fairness. It is important, particularly when you are negotiating a contract for a large project, or any project that is substantially different from your usual projects, or your usual contracts, to retain an attorney to give a second set of eyes and point out any potential risks. That is what we do here. I look forward to working with you.